Hi, I'm Tracy Murda, and I'm here with family law attorney Kelly Peterson, who is a specialist for parental alienation cases, estrangement cases, and cases involving parent time interference and gatekeeping. For those listeners just joining us, Kelly, could you give us a bit of a recap of what we discussed in our last two segments and a roadmap of our discussion for today?
You bet, Tracy. In section 1, what we discussed was what parental alienation looks like, what behaviors alienated children engage in, what the alienating parent's behavior looks like, and how that plays out in preventing the target parent's parent time, damaging the relationship with the target parent and the child, and what kind of psychological and developmental damage that does to the child, him or herself. In the second section, what we talked about was how attorneys and courts and therapists and guardian ad litems can sometimes respond poorly and make the problems worse due to misconceptions about parental alienation and how to deal with it, and why so many attorneys, even experienced family law lawyers, can actually harm their client's alienation case by doing the wrong things.
Excellent. Thank you, Kelly. So what's on deck for today? What are we going to talk about?
Today, we're going to talk about the nuts and bolts of how someone can actually prove parental alienation, how to gather and organize the evidence, and then also effective and ineffective remedies that the court can fashion to help fix the problem.
Gotcha. Before we get started on those 2 points, you mentioned there might be a couple of cleanup or additional points about some of the previous topics that we talked about.
Yes, Tracy, I think it might be helpful to add just a few ideas about the behavior of alienating parents and alienating children that we didn't have time to discuss before. And so let me just add a couple of points on that. One is that alienation can be either overt, like flat out disparaging, but it can also be more subtle. It can be covert.
What do you mean by that?
Well, the alienating parent can pretend to be concerned about the target parent, but really just be highlighting the target parent's flaws to the child or how unsafe the other parent is. For example, an alienating parent can say, I really love your mom, but she's making some bad choices right now. Or even praying with the child, dear God, please bless that your dad won't be such an alcoholic anymore. Repeatedly texting the child and asking the child if the child feels safe with the other parent or when they're on parent time with the other parent, thereby suggesting to the child that the child may not be safe. Another behavior that is more covert is insisting that the exchanges take place at a police station parking lot, or fleeing with the child and taking the child, say, to a shelter, taking the child to environments where there is an implication that the reason they're there is because the other parent is unsafe. But lots of times, alienation is done with the best of intentions. Sometimes an alienating parent thinks that they're just telling the truth about the negative things of the target parent to the child.
But why would that be a bad thing, Kelly? Isn't honesty the best policy?
Not always. Sometimes an alienating parent just doesn't understand the burden that they're placing on the child and how it harms the child emotionally and developmentally to discuss negative aspects of the target parent. Even if they think those things are the truth, many alienating parents think telling the truth is a defense to anything. I'm never going to be dishonest with my child, they'll say. What they don't realize is they're treating the child not as a child, but as if they're just a little adult. The first problem with that is that the alienating parent doesn't have the corner on truth. It's a mighty thin pancake, doesn't have two sides. There's usually another side to the story. The other problem is that even if what they are saying really is true, it can still harm the child. We generally don't tell 5-year-olds about how babies are made or all the awful things that serial killers do, even though that might be the truth. Neither do we tell a 15-year-old all the negative things about the other parent, even if they're true, at least from our point of view, because that usually still harms the child developmentally.
Okay, but what if instead of telling the child the truth, they're asking the child for the truth, like where the child wants to live, for example?
So another way that, whether intentionally or unintentionally, alienating parents can harm a child is by creating loyalty conflicts. This often occurs when the alienating parent specifically asks the child things like, where do you want to live? Who do you want to live with? Do you want to go on parent time with the other parent? Do you want to have a telephone call with the other parent? Even asking the question can create a loyalty conflict and can be the equivalent of asking, who do you love more, me or the other parent? The child's in a no-win situation at that point and will often side with whoever is asking the question just to avoid having an argument or making the asking parent feel bad. Or, you generally don't bite the hand that feeds you. So often the child will simply side with the parent that they get more stuff from, whether it be care or toys or fun time or those kinds of things. But then the alienating parent will sometimes compound the problem by requiring the child to live by their original statement. This can happen when they say things like, hey, remember, kiddo, you're the one that decided that this is what you wanted. Then the child feels responsible to stick with what they told the pressuring parent, even if that's not what the child really wants. Kids just are not cognitively equipped to remain unharmed by that kind of pressure. Another subtle method of alienation that I wanted to talk about that we weren't able to discuss before is best illustrated by this situation. Imagine, Tracy, if you would, a parent doing the dishes or some other task, and the child is talking in the background and the parent has half an ear on the child, but is largely focused on their work. Then the child, who can sense that their parent isn't entirely listening, mentions something negative about the target parent or talks about how the target parent mistreated them in some way. The listening parent then stops doing whatever they're doing. They stop doing the dishes and they turn around and they give 100% focus and attention, laser-like focus on the child. And that feels good to the child. The parent starts asking the child questions and the kid realizes, wow, look at all this attention and sympathy I'm getting. This is great. I guess I'll keep talking more on this subject. And the child realizes that they're essentially getting an emotional pat on the head for whenever they mention negative things about the other parent. They feel emotionally rewarded. So the child talks more about it. And now the child has an incentive to exaggerate, embellish, and talk about how hurt they feel and get even more attention and sympathy. Parents generally are not trained to do forensic interviews, and they mess it up. And they'll pull false or exaggerated allegations out of the child instead, not even realizing what they're doing. And even sexual or emotional abuse claims come out this way. Unfortunately, often the child then feels like they need to stick to their story so that they're not later condemned as a liar. Now, abuse can and should be properly investigated and taken seriously. I'm not saying that abuse is out of the question, but for purposes of our discussion today, I'm assuming cases where no abuse has actually occurred. I'm just illustrating how false allegations sometimes happen or how negative things about the other parent are sometimes inappropriately emphasized.
But what should they do if the child does disclose abuse?
Well, they certainly shouldn't keep pumping the child for information, harming the child emotionally, and also tainting the evidence, tainting the interview. If there is abuse, they should report it to the authorities, law enforcement, or DCFS. But if what the child is describing is just poor parenting, talk to the other parent about it. Talk to a therapist, but don't keep interrogating the child.
Thanks for adding that to our prior discussion with those points. It's really important stuff. But now let's turn to one of the most important questions. How do you prove parental alienation?
I am going to give very concrete, practical steps of things that can be done to prove alienation. But the best place to begin is what not to do. So let me start there just for a minute. Lots of folks want to spin their wheels focusing on the motives of the other side. Dad is just trying to turn the children against me. He hates me, and now he's trying to get back at me kinds of statements. Those are generally not productive. The motives of the other parent are rarely provable, and they're often not even relevant. At the end of the day, we don't really care whether the alienating parent is intentional, unintentional, or simply reckless. It is their behavior and their attitudes we need to spend our time focusing on, not their motives. There's one exception. to that. And that's if they're just plain ignorant. If a alienating parent, once in a while you get a case where the alienating parent just needs to be educated just because they're kind of dumb. And if they know better, they'll do better. Unfortunately, judges think this is the case far more often than is really the case. And that if they just throw a high conflict parenting class at the alienating parent, that will fix things. One of the biggest mistakes that parties and their attorneys make is simply providing to the court a few examples. They'll give 3 or 4 examples of alienating behavior, and then they'll claim that's a pattern to the judge. Judges hear and discount allegations of that's a pattern all the time. They are waiting for the parties to connect the dots. You cannot connect the dots unless you have enough dots to connect. How do you prove a pattern? You prove a pattern incident by incident by incident. That takes an enormous amount of work, of preparation. And I'll explain a little bit more how to do that later. Another mistake that folks make when they're trying to prove alienation.
Okay, so I think I understand what not to do, but what do I do if I want to prove alienation?
Okay, so one of the first things that I have my clients do is build a chronology. When done right, this is a document that will be 80 pages, single-spaced. Date on left, event on right. Date on left, event on right. And they'll go all the way back from the beginning of when the problem started. I have them describe everything. This is an enormous assignment. It's frustrating. It's time-consuming. It's irritating. Sometimes it's traumatic to have to relive all that stuff. I have them go through their text messages, their emails, their journals, their social media, their own memory, and write it down. So I also have them quantify things in their chronology. One mistake that folks make is they use words like rarely, frequently, often, always, never. I want them to quantify it. Once a week, twice a month, 3 times a year. This chronology becomes one of the most useful tools in the attorney's tool bag. And because of how time-consuming and irritating and tedious it is, a lot of folks just don't put in the work. They don't want to. One of the things that we also do is interview witnesses, friends, family members who have observed alienating parents' behavior or the behavior of the alienated child. Those folks should be interviewed. Sometimes I will do the interview. Sometimes my paralegal will do the interview. Or sometimes the parent can just talk to them. Depending on your state, you may be able to record the interview. You can ask the witnesses to send you an email, and you draft a declaration for these folks to sign, and that information gets dumped into the chronology. You can also engage in what's known as paper discovery.
What is that? I don't think I've heard that one.
Paper discovery are methods attorneys can use to gather information to help bolster your case. For example, one most folks are familiar with are a subpoena. We can subpoena bank records. In some cases, you can subpoena therapy records. You can subpoena telephone records, etc. You highlight the good stuff. You dump the good stuff into the chronology. There are other forms of paper discovery as well. There are requests for admissions, for example. Generally, you get 10 of these. And a request for admission is a formal document you send to the other side saying, please admit X, Y, and Z. They have 28 days to file an answer and to either admit it or deny it. And if they let the deadline slip by, then everything that you've asked them to admit becomes truth for purposes of the case. So some examples might be, please admit that father is a good father. Please admit that the child would benefit from large amounts of time with each parent. Please admit that it would be developmentally harmful to the child to have parent time interfered with, or whatever. I often ask questions that it doesn't matter whether they answer, admit, or deny. It's helpful either way. You also get 10 interrogatories, generally speaking, 10 open-ended questions that they have to answer in writing under oath within 28 days. Some examples are, please tell me all my strengths as a parent. Please tell me all your weaknesses as a parent. Please tell me what you think good co-parenting means. Please tell me all the reasons why you believe that the child should or should not have parent time with me, etc. And very often the questions, it doesn't matter how they answer, it's helpful. You also get 10 requests for production of documents, generally speaking. These are like 10 subpoenas on the other side. Please provide me all your bank records. Please provide me all your telephone records, those kinds of things. So that's what I refer to as paper discovery. And you get that paper discovery back, you highlight the good stuff, and the good stuff gets dumped into your chronology. Now, when you get the paper discovery back, it's likely to be chock full of objections, complete answers, and those kinds of things. Only about 25-30% of the responses you get back will generally be helpful. What you can do is, to the extent that it's garbage, you can file a motion with the court asking the court to force the other side to supplement their answers. Generally speaking, when you file that motion, about half of the stuff, sometimes more, sometimes less, the court will order the other side to supplement their answers. And with those supplemental answers, you highlight the good stuff that gets dumped into your chronology.
Then can anything the child says be admitted in court? Isn't that hearsay?
Generally speaking, it is. But there are ways of getting hearsay admitted into court. There are exceptions to the hearsay rule. Therapists can often get hearsay in. If there is a recording of the child, that will generally be admitted. In alienation cases, a deposition of the other party, and sometimes their spouse, is critical. After all of the data is collected, you've got your chronology, you've done your paper discovery, you've supplemented it, and you have got as much evidence in that chronology as you can. That's usually the best time to do a deposition. Now, what is a deposition? What if we were to send a notice to the other side saying, you are required to come to the law office of Kelly Peterson on such and such a day. There will be a court reporter, a stenographer present who will put you under oath to tell the whole truth. The judge will not be present. Kelly is then allowed to ask you questions on the record up to 7 hours. It's pretty hard to avoid 7 hours worth of questions. Many attorneys make the mistake of using the deposition to do their initial data collection rather than using it for confrontation. During the deposition, you ask questions. You ask questions to elicit not only their behavior that they've done in that past, but also, very importantly, their attitudes. Some questions might include such things as this. Hey, between you and the other parent, who has the greatest degree of influence over the child? How do you feel about the other parent? Is the other parent a good parent? Do you trust them as a parent? How do you feel about them? Now, the kids need both a mom and a dad, right? How firmly do you believe that? Why do you believe that? And there's no win there, because if the alienating parent says that yes, the other parent is important in the children's lives, great. And if they say no, the other parent isn't important in the child's life, great. Either way, it's helpful to you. Either they are ignorant and lack insight, in which case their alienating behaviors are likely to continue, or they know exactly what they're doing when they engage in alienating behavior. How important is the other parent in the child's life? Have you ever engaged in any conduct contrary to that belief? Have you ever engaged in this kind of behavior or that kind of behavior? Disparaging, asking the child for preferences, transferring your anxiety about the child's safety to the child, and you can describe what that looks like. Have you ever done anything that would tend to diminish the child's affection for the other parent? Have you ever done anything to gatekeep or interfere with the other parent's parent time? On a scale of 1 to 10, how firmly do you believe that? And then is when you pull out your chronology. Okay, what about this incident? What about that incident? For example, a text message was sent saying, you're such an awful parent. The child has decided that he doesn't want to go with you and I support his decision. Great. That's a text message you sent, correct? Do you think that was appropriate? Do you think that was helpful to the child? Whatever they give you, it's often helpful. Lying is okay. Squirming is okay. Justifying is okay because it demonstrates their attitudes. Now imagine doing that kind of thing and asking those kinds of questions for up to 7 hours. Now you are in a position to prove patterns because you have gone through incident by incident by incident. You've built your chronology, you've done your paper discovery, and now you've deposed the other side, confronting them with that data.
Once you're just done with the discovery and deposition, what do you do with it?
You go through the deposition transcript, you highlight the good stuff. The good stuff gets dumped back in to the chronology again. When you go to trial, if you have to go to trial, guess which questions you ask the other side? Only those questions that you've highlighted. Why? Because if they deviate this much from their answer previously, then you can confront them with their deposition transcript in open court in front of the judge, showing they're a liar. And because you're asking them only the questions that are helpful to you, your examination of them is powerful. Every question is a zinger and helps demonstrate your case. Now, if there is a custody evaluator or a parental fitness evaluator or a therapist, give the highlighted transcript to the therapist or evaluator, or to DCFS, or to other third-party professionals that are involved.
In the last segment, when we met, you mentioned that traditional therapy doesn't really work to fix alienation, but can therapists be helpful in other ways?
Absolutely. Therapists can help, first of all, prove alienation. The statements of a child and an alienating parent during therapy, in many circumstances, can be brought before the court. But a therapist can also help the child cope with enforcing parent time. Let's suppose you have an alienated child who doesn't want to go on parent time. The therapist can say, hey, kiddo, I'm not here to change the court orders. The court orders are what they are. And you still have to go on parent time. What we want to do is give you coping mechanisms to help parent time be a good experience for you. You don't have a choice about whether to go, but you do have a choice about what attitude to take when you go. So let's work on that. Another significant tool, an attorney's tool belt to prove alienation, is the use of expert witnesses. A custody evaluation, a parent time evaluation, a parental fitness evaluation. These are psychologists generally who are trained to do forensic evaluations, who gather data, sometimes do psych testing, interview witnesses, put all of the evidence that they've gathered in the middle of the table, and then say, okay, what does this mean? They render an opinion for the court as to what's going on and how to fix it. What are the strengths and weaknesses of each side? What are the needs of the child? Is there alienation going on? What is necessary to repair the relationship with the other parent? Those kinds of things. A lot of times, attorneys make the mistake of relying too much, though, on the evaluator. Evaluators are generally therapists. They're nice people, and they're generally not going to spend 7 hours asking hard-hitting, hardball kinds of questions. The evaluator will spend a total of maybe 3 hours over 2 interviews interviewing the parties, and half the questions they ask are going to be softballs. So when they get the transcript of a hard-hitting deposition, they love it because that's data for them upon which they can base their evaluation. But a lot of times attorneys simply say, oh, let's just have an evaluation and the evaluator will sort it out. But psychology is a science. It's a soft science, but it's a science, which means that it relies on data. As Sherlock Holmes would say, we need data, data, data. And if there is a lack of data, or if the data that is provided to the evaluator is garbage, it's garbage in, garbage out. How can you expect a good result from an evaluation if the data that was provided to the evaluator is garbage? One of the jobs of you and of your attorney is to develop the evidence so that you can spoon feed the data to the evaluator. Now, and presumably the other side will be doing the same, but more data is better. Don't just rely on the expert alone to do all the data gathering for you. And those are the main tools that an attorney will use to prove alienation.
Okay, so what can a court do to help fix the parental alienation issues?
Early intervention, when alienation is nipped in the bud early, that's the most effective. The remedy depends on whether or not the alienation is mild, moderate, or severe. Severe being, the child's running away and just refuses to go. Mild is they resist a little bit and maybe have an attitude problem against the other parent because of the alienation. It also depends on how long-standing the alienation is. As we discussed in the last segment, what doesn't work are threats and lectures from the judge, traditional therapy, or a cooling off period, or reducing or supervising the target parent's parent time. Instead, what the court can order is a combination of a variety of things. First, an attorney can file a motion to enforce or an order to show cause. This is a motion to have the other side held in contempt, saying, hey, here was the court order. They had the ability to comply. They knew about the court order and they failed to comply. And if you can have the other side held in contempt for that behaviors, the court can sanction them with fines, paying your attorney's fees, removal of driver's license, even jail time, community service, and various things. So if you can have the other side held in contempt for their behaviors, sometimes they'll get the message, and sometimes that's something that can be done early. Another thing that you can use is a temporary restraining order. If you can demonstrate that the alienation is severe enough, you can ask the court for an immediate order suspending the other parent's parent time until you can get a hearing in 14 days to demonstrate why a preliminary injunction should enter, making that permanent. Now, you have to demonstrate by clear and convincing evidence that immediate and irreparable harm is occurring to the child. So depending on the quality of your evidence and the severity of the alienation, that is an option. That can occur very quickly and can help nip alienation in the bud. You can also file a petition to modify the decree, changing custody to the non-favored parent, award the non-favored parent additional parent time, make up parent time. In combination with these and other remedies, you can require the favored parent to write apology letters to the child, explaining how they alienated the child, explaining their poor behavior, their mistakes, so that the child, with additional therapeutic support, can begin to change their own attitudes. In combination with those, you can require the favored parent to exercise all of their parental authority, for example, imposing negative consequences for a child's failure to attend parent time. Now, some language might include this. What if you were to change the court orders, file a motion to change the court orders to include this language? Ensuring the other parent's parent time. Each parent is specifically directed to enforce the court-ordered parent time, except as the parties otherwise agree in writing. The children are not given the choice whether to attend parent time. They are ordered to do so. Thus, if the child declines to visit or have contact with the other parent as ordered, the parent with the child will provide continually escalating consequences to the child until the child complies. For example, removing privileges, taking away cell phones, prohibiting time with friends, prohibiting time on electronic devices or games, taking away driver's license, disallowing extracurricular activities, volunteering makeup time with the other parent. In extreme cases, reporting the child as a runaway and ungovernable and placing the child in respite care. Additionally, the parent can provide incentives and rewards for the child complying with the court's orders. The parent who does not have parent time will not allow the child to return to their home, will not give the child a soft place to land other than the other parent's home. For example, they will only allow the child to stay at the other parent's home during the other parent's parent time. It will be the responsibility of the parent who has the child to enforce parent time and contact with the other parent. When providing consequences to the child, the parties will in no way suggest to the child that it's the other parent's fault that the child is being given consequences, or that the other parent could simply agree not to exercise their time with the child. To the contrary, the parent giving the consequences will actively promote the opposite viewpoint, will take full responsibility for the consequences administered, and will state they are doing so because the child's time in contact with the other parent is so important. Getting those court orders put into place sometimes will nip it in the bud. You can require court orders that neither party will schedule events for the children on the other parent's parent time, or allow the child to do so except as the parties otherwise agree in writing. So in combination with other remedies, requiring the favored parent to pay a set fee or a fine for every day of missed parent time. Other remedies that the court can order can include a temporary no contact or less contact order with the alienating parent while the child spends more time with the target parent, while the child is in therapy to help the child cope with their new situation. You can enter orders about cell phones and electronic communications that each party gets to log in, to have the login credentials, and that no secret communications will happen with the child. You can enter orders against tethering. In other words, that the alienating parent can't be sending 700 text messages per day to the child or calling the child from 10 to midnight every night. In some severe cases, a court can order the child to be placed in residential care for a while. Now, let's suppose, Tracy, though, that the child is threatening self-harm. If the child is threatening self-harm because I'm going to kill myself if I have to go to the other parent, or cut on myself or something like that, there can be a court order that the child be taken to the emergency room to evaluate whether the child should be admitted. And if the child is deemed safe to be released, or once they're safe to be released, they get released to who? The non-favored parent. Because then you have a residential care facility or a doctor or a psychologist that is there to say, hey, we're going to release you to the non-favored parent, kiddo. And if the child then says, well, I'm going to kill myself, okay, I guess you need to stay here longer. But now you have a third-party professional who is trained to evaluate the child, who can assess when the child is ready to be released. And so the child should generally be released to the non-favored parent's care, with the hospital staff evaluating whether the child's safe to do so. And if they're not safe to do so, then the child should stay. What you shouldn't do is have the child released to the favored parent's care, because then the child now has a ready excuse to get out of parent time by claiming I'm suicidal or cutting on myself. And so just take me to the hospital and mom will pick me up later, or dad will pick me up later, whichever the favored parent is. You can ask for orders that the child admitted to the residential care will stay there until the child is deemed safe to be released to the non-favored parent. This both ensures the child's safety and also avoids the child or the favored parent using these kinds of threats to balk the court's orders regarding parent time. In essence, calling the bluff of the alienated child or the alienating parent where the threats of self-harm are being used in an attempt to manipulate the court. In some cases, you can ask the court for what's called a writ of assistance or a pickup order. This authorizes law enforcement to pick up the child wherever they're at and deliver them to the non-favored parent. This is kind of an extreme remedy, but sometimes it's ordered. And usually it only takes a few times of law enforcement going and getting the child with the authority of the court and then taking them to the non-favored parent for the child to say, oh, okay, I guess I really do have to go. Other things that can be done. There are specialized reunification programs. There's a few of these across the country. They're very expensive, unfortunately, and they have waiting lists. But there are special camps where you can send the child to away from the favored parent with the non-favored parent, where they do really intensive therapy over like 4 days or a week or so to detoxify the child and help repair the relationship with the alienated parent.
So, Kelly, how can an attorney like you who specializes in parental alienation cases help? And where do you help? Do you just cover Utah? What about outside of the state?
My role might differ depending on whether I'm assisting a client in Utah or someone outside the state, which can be done in some ways. Obviously, I can represent clients in Utah, throughout Utah, doing any of these things that we've talked about. I can also be co-counsel with another attorney to help organize the evidence, case planning, deposition, and trial planning, develop and organize the evidence, helping to coordinate with therapists and evaluators, and that kind of thing. Pro hoc vice, a limited scope, out of state with another in-state attorney.
Well, this has been another great session with family law attorney Kelly Peterson, who, again, specializes in parental alienation cases, estrangement cases, and cases involving parent time interference and gatekeeping. If this is an issue for you or someone you love, you won't want to miss the previous segments we did as well. In those previous two segments, we talked about alienating behaviors of the alienated child and the parent, and how the child is mentally harmed by alienation, and those misconceptions, even judges, attorneys, guardian ad litems, and therapists, and how they can get it wrong about this complex area. If this is an issue you struggle with, don't hesitate to contact attorney Kelly Peterson's office to see how he can help. Thank you so much, Kelly. This was another great session that I'm sure is going to help a lot of people.
It was a pleasure to be here. Thank you, Tracy.